everyone, and welcome to the Immigration Insights podcast. My name is Kate Kalmakov, and I am your host. I co-chair the Global Immigration and Compliance Group at Greenberg Traurig, and I'm so lucky to be joined today by my colleague, Kelly Bunting, who is a shareholder in our Philadelphia office. Kelly has a very interesting practice that focuses on traditional labor and employment, but she also does a lot of cross-border work. So Kelly, can you please introduce yourself and tell us a little bit about your practice and what you're focusing on these days?
Certainly, Kate, and it's lovely to be here. So thank you for inviting me, and it's always great to work with you, of course. My practice focuses, as you say, on a lot of traditional labor and employment issues that employers see day to day. This is daily counseling on hiring, firing, disciplinary actions, of course. We've seen a real rise in free speech at work, for lack of a better phrase, issues where employees will speak out about things that are very important to them on their social media accounts. Somehow their comments get back to customers or clients of their employers, and there's some sort of disagreement in viewpoints. We've seen a real rise in those claims. So a lot of counseling around, can you discipline an employee for off-duty conduct or for their social media posts, or if they join a rally, can you discipline for that? Can you terminate employees for that? So there's a lot of counseling involved. There's litigation, of course, always litigation. Unfortunately, wage and hour litigation is still really strong. Class action, collective action in the wage and hour arena. We're seeing more actually discrimination claims as well, and two in particular, religious accommodation request and discrimination based on that, and also on disability claims. Employees that are asking for, I need to work from home. I need several days off. I need intermittent FMLA. I need some sort of accommodation, particularly when it comes to mental health, as opposed to more physical disabilities. Mental health in the workplace seems to be a real issue right now, and it's not that surprising coming out of COVID. We're 5 years out, not quite 6 years, and we're still seeing the effects of that in the workplace. So a lot of counseling around those issues. But as you know, Kate, and you mentioned it, a substantial portion of my practice is cross-border employment issues, labor and employment issues, which is where we tie into immigration issues so often. Secondment agreements, employment agreements, separation agreements. I have a number of overseas clients, and I give them counseling draft agreements for them for their U.S. employees. Obviously, I'm not qualified to counsel on Danish issues or on Indian employment issues, but when it comes to their employees in the U.S., that's what I do a lot of work for the clients in. And then also any clients that are based in the U.S. that are sending their employees overseas, perhaps opening new locations overseas, I will give them guidance on who to go to, PEOs, EORs, some issues that might crop up, and also counseling and advice on U.S. labor and employment laws that actually will apply overseas. There's not a lot of them, but there are enough that U.S. employers should be aware. So that kind of wraps up what I do.
Well, that's really interesting. And there's so much overlap between our practices. I really always enjoy chatting with you and seeing the similarities. And so often we work with HR and they have to loop one of us in because there's a conflict also between the employment and the immigration laws, or there's changes that align. And so we really need to work with each other on a lot of these issues. For example, you brought up social media and the protection of free speech. Well, the administration this year has been very focused in their security background checks of visa applicants in reviewing social media postings, and they are requiring for the issuance of non-immigrant or immigrant visas that social media accounts not be locked, that they're public so that they can review them. And you have to list all of them now on your visa application. And for applicants in the United States who, for example, were on student visas, a number of student visa holders had their visas revoked for making posts that were perceived to be anti-American. So there's definitely, I think, an overlap and perhaps a tension and conflict between the employment law and the immigration as well.
It's quite a new development, but one that's very interesting.
You also brought up the work you do on secondment agreements and cross-border work. And of course, for that, they can't be drafted in a vacuum, right? Because a lot of times you will be dealing with people bringing employees to the United States, and they have to address visa concerns. So we have to talk about in those agreements what you as an employer are permitted to promise, what you are not permitted to promise. And there are so many times we come into a situation after the fact where we haven't been retained at the outset, and the employment agreement promised to sponsor a green card even if employment was terminated, which of course is problematic from a representation issue to a U.S. federal agency. So what kind of issues are you looking for when you're doing those types of agreements? And, can you talk a little bit about the items that you're flagging? And also, how does U.S. employment law apply overseas?
You are so correct on that. Immigration and labor and employment, it's always been linked, but I would say in the past several years, they're absolutely vital to each other. In almost everything that I do when I am counseling overseas clients, there is some sort of immigration issue. For example, you mentioned student visas, and I had a client based in India who had a number of intern positions, and we were talking about, okay, let's draft some sort of memorializing of the relationship as these students were interning at the Indian-based company's U.S. locations. Well, all of them were on student visas. And as you mentioned, student visas are quite a minefield right now. And so we had to stop that process kind of mid-process and get immigration involved in that. You mentioned the sponsoring too of an H-1B, for example, and I had a client based in Spain that wanted a contract for an employee that they were sending to the U.S. They were going to, of course, sponsor the H-1B, and they wanted it written into his employment contract that if he left before 5 years, that he would pay back all of the fees that the client had paid to get him his visa in the U.S. And I had to explain you can't do that. You can't make them pay you back. I think the expedited processing fees they can be responsible for. Is that correct? But
correct. The Department of Labor, to make sure that these applications are bona fide, requires employers to pay them. And it's interesting because requirements differ visa to visa. So in the H-1B category, it's extremely strict. In another category, the same rules don't apply. So it's also critical to consult with Immigration Counsel so that you actually know what you can and cannot promise and require.
And the rules keep changing. I listen to your immigration podcast. I read the immigration blogs because they keep changing, and that impacts what the other things that we as labor and employment lawyers do on a regular basis, such as mergers and acquisitions. They've slowed down a bit, but they're still happening. And immigration issues have really come to the forefront of labor and employment due diligence in these M&As. So when I'm looking at various employment-related issues in a typical M&A transaction, do you have a union? Do you have a collective bargaining agreement? Let me see the collective bargaining agreement. Let me review your handbook. And now we always ask and make sure that we get very specific responses to do you have any employees in the U.S. who currently hold visas? We need a list of those people. We need the type of visa, as you say, and at that point, I'll get my immigration colleagues involved so that they can review this and see, are there going to be potential issues in transferring some of these visas to the new owner, or if we have to terminate these folks, how do you terminate and stay within immigration law compliance? And some of the visas, they have to leave the country pretty quickly, correct? If they don't find another position, which is really quite frightening to employees that are already afraid when they hear that the company is in talks to be sold. So there's a lot of hand-holding, a lot of winning hearts and minds in these transactions now that previously really we didn't have to worry about before some of these more current rules.
I think in the M&A context, it's interesting because we sort of have two issues. One is, how do we structure the sale? Is it an asset sale? Is it a stock purchase? And what the issue with structuring the sale is, are we going to assume the Form I-9s of the company that we're purchasing? And many times we're assisting in the M&A deals, as you know, to review the I-9s, which apply both to foreign workers and U.S. workers. All employees hired after November 6, 1986, according to the Immigration Reform and Control Act, have to do a Form I-9 to verify their employment eligibility and their identification in the country. And many times in these M&A deals, we see I-9s that are just a mess. They're not completed. There's missing.
Very true.
And we have to advise our clients that unless that company performs an audit and fixes them, and you can't even fix all of the issues, because if somebody's terminated, certainly you can't re-I-9 them. You're going to have to assume that liability. And oftentimes we're coming up with a financial analysis for them of, if the client fixes, how much are you liable for? If they don't cure, then this is what you're going to be on the hook for. And you can't just re-I-9 everybody either, depending on the type of deal it is, because re-I-9ing may be considered discriminatory and run afoul of DOJ requirements. So that's very challenging. And also the second part of that, as you correctly note, is if the company employs foreign nationals, the successor in interest has to step into the shoes and continue those immigration applications. But you have to know that they were filed properly, the correct wage categories and classifications for the position were used at the correct level, and that everything was done really bona fide and properly, because this administration right now and in the past year has been laser focused on compliance, on investigating employers sponsoring visas, investigating companies for I-9 compliance issues, specifically focused on the H-1B and compliance with the wage requirements. And they are investigating extremely rapidly across the country. They are levying fines. It generates revenue for them. And employers, have to be aware of that. And if you're in an M&A scenario, it's even more important, because it really can be the deciding factor if the deal goes through or not. And on the employment side, it must be similar to what you're looking for when you're analyzing a deal as well.
Indeed, that's so true. What you just said. I have seen M&A deals that have not gone through. They've just stopped negotiations. They've stopped the acquisition simply because of potential immigration issues and companies not really wanting to be on the wrong side of that law these days. It makes the transaction much more expensive, as you point out, and simply more difficult. We had an example of a South American-based company was buying a Texas-based company. In doing the review of the employee census, we recognized that there were several employees that had simply been working illegally for years. They had pending visa applications. They had missed their court dates. I don't know how you miss a court date when you've been waiting 10 years for one, but in this instance, we did have an employee that did that. And for the transaction to move forward, the seller of the company was required to let these people go, to terminate their employment. And after years, because they had simply not been working legally. And then, of course, we addressed all the other issues that arose out of that. So that's become a focus as well, in addition to the religious accommodations, the disability accommodations. We're also seeing companies that want to have these uniform policies around the world. So they've got locations in Singapore, they've got locations in Europe, they've got locations in South America, and they have their US locations. So we'll get asked, well, just write us policies that will apply to everybody. You know, Kate, you know this. This is absolutely impossible because so many laws don't apply, do apply. You are actually triggering liability for the employer if you try to make some of these laws apply overseas or vice versa. You don't want to invite that kind of potential litigation if you don't need to. So there's a lot of education, I guess, is the best way to say it. I'm sure you do that as well. Just educating clients on what can and can't be done, and why it's not a good idea to try to make your policies apply across the board. There's very liberal, very employee-friendly policies in the EU, for example. I swear one of these days I will get a job in the EU and live there simply to avail myself of the multiple leaves that are available and the job protection and, you know, all the lovely things that are available in the EU that aren't available to employees in the US. So that's something that it's just education. That's all. It's just explaining why you wouldn't want to give all of these benefits to your U.S. employees if you don't have to, and pointing out the benefits that the U.S. employees perhaps may want to avail themselves of instead of that. Another thing that comes up all the time, restrictive covenants. Restrictive covenants pretty much are regulated around the world. The U.S. is one of the few jurisdictions where you can have restrictive covenants for your employees. But even in the U.S., we see California, Minnesota, New York, New Jersey, Illinois. There are a number of states that have now put restrictions on who can have a restrictive covenant, how long it is. Even Massachusetts came out with a form of garden leave, which was quite surprising to those of us who practice labor and employment, because garden leave, which is simply paying your employees throughout the non-compete or the non-solicitation period, that's very common in the EU. We've never seen it in the US, but Massachusetts passed a law that has a lot of those same the same terms that you would see in an EU agreement. So very interesting times, I would say, in the labor and employment.
I was going to say, you know, I can't imagine clients asking for a global policy when the state employment laws differ so vastly between them. And obviously we run into them in the immigration world too, whether it's pay transparency or, you know, how to lay off employees or things like that.
Yeah.
So I can't imagine how difficult it is to develop a just US even policy, and if that's even possible.
We get a lot of questions about that. We actually have done presentations for clients on U.S. employment law for non-U.S. employers. It's like a primer. We get a lot of questions with, well, it's at will. The U.S. is at will, and that's such a freeing concept, shall we say, to countries that heavily regulate their employment. And so they come to the U.S. and they say, this is great, we can do anything. we can fire our employees for any reason. Well, not for any reason. It can't be a discriminatory reason. And certain states certainly do have prohibitions on firing. So we have to explain, yes, it's at will. Yes, in essence, generally, you can hire and fire at will in the US. It is very different from other countries. However, it's you cannot just fire folks for any reason, even in the US, without looking at, was the person recently on leave? Did the employee recently complain or file an internal whistleblower complaint? Has the employee perhaps lodged a complaint against a supervisor for sexual harassment? And then the company moves to terminate that employee within, weeks of this internal complaint being filed, or within weeks or days of the employee returning from protected leave. These are all questions that you have to ask yourself. And hopefully HR is involved in each of these decisions, because HR has access to benefits files and has access to medical issues that perhaps a supervisor does not have access to. And HR should be able to step in at that point and say, wait, this person is on a protected leave, just came back from a protected leave. Let's talk about this and try to prevent the company from creating liability for itself, in essence, because it's not thinking through all of the different ways that, or all of the different restrictions on firing in the US that, maybe it's not written in a law, but it certainly is in practice in the US. And so you have to be aware of what's happening here and what's happening state to state.
And of course, there's collective bargaining agreements. As you mentioned, there's unions, and that must certainly complicate things as well, especially if you have a new company from overseas opening operations for the first time in the United States. Their employees are unionizing, and that's a different ballgame.
Yeah. Or in the case of some companies, they expect that there will be a trade union or a works council representing their employees in the US. And, we look at them and say, no, there are no works councils here. I often get the question, well, how do companies operate? We stay within the law because we don't want to get sued, and also because it's the right thing to do. Employers in the U.S. tend to be very well aware of all of the laws that apply to employment in the U.S., and they take many, many steps to ensure that the law is complied with. And these are basic steps that most U.S. companies know, and that perhaps companies overseas don't. And that's audits, wage and hour audits, immigration I-9 audits, handbooks, employee handbooks, and updating those handbooks regularly, making sure you have state supplements for those handbooks. If you are in states that have a lot of employee protective type legislation, such as California, Illinois, New York. And I don't mean to keep calling out those states. There's certainly other states that have employee protective legislation now as well. Training your HR folks, training your supervisors, training your employees on how to comply. This is something that every U.S. company does or should be doing, that maybe companies overseas don't really think about because they operate in a heavily regulated arena. And that's not here. Really, employers regulate themselves a lot with an eye towards U.S. employees tend to sue a lot more than employees overseas, where they live in under more protective rules and laws.
Now, I know a lot of our clients turn to you, Kelly, to do the trainings that you mentioned, and that you have been really quite active traveling around the country doing different types of trainings. What are the lessons coming out of that? And what do you think employers should be focused on that doesn't get enough attention? You mentioned disabilities, you mentioned discrimination. Those are big ones. But what else?
It always surprises me when I talk to employers, even large employers, multi-state employers. It always surprises me that they don't train their supervisors in good management techniques. They'll train in sexual harassment, other forms of harassment, discrimination, and retaliation. Almost every employer does that. And they'll do it on a fairly regular basis. And if they are in jurisdictions that require live training or training more often, they keep up with that training. But, the number one protection that an employer has against being sued for employment-related issues is not human resources. It's your supervisors. It's your layer of management. Those are the folks that really can keep you from getting sued as an employer and get you sued as an employer because they're not properly trained. So training your managers in good management techniques, and by this I mean how to properly interview. If you don't have recruiters doing your interview, if you as the supervisor or the final interview, what questions to ask, what questions not to ask. It still surprises me that supervisors that are really good at their job are not that good at hiring. We train them on good management techniques such as how to discipline in a fair manner. So many of the lawsuits that I see coming across my desk involve a new supervisor. So you have a former supervisor that maybe had been there for a while, didn't necessarily enforce all the work rules, kind of let employees get away with things, didn't keep up with the performance reviews on a regular basis. And then you have the new manager coming in who's been trained and who realizes, okay, well, you haven't been doing this and you haven't been doing that, and starts really enforcing the rules, talking about the handbook, talking about the code of conduct or the mission statement, and trying to get employees on board. This is, you've really got to ease into that if you've got a previous manager that has not necessarily enforced the rules. A lot of lawsuits can come out of that because employees need to be put on notice of what the rules are before you hold them accountable for those rules. Basic management principle is talk to your employees, talk to them, talk to all of them. I always say, not just the ones who show up on time and don't give you any trouble. Talk to all of them. Become invested in their success. And in turn, your employees will become invested in your success as a manager. I firmly believe that. I see so many lawsuits that could have been avoided with proper management training. And I see so many problems in the workplace. Maybe it doesn't result in a lawsuit, but it will result in employees leaving the company. Good employees. These issues can all be fixed with good management training. And an employer holding managers accountable for their own performance and their own lack of understanding as to how to manage a workforce, especially a multi-state workforce in today's environment.
I think that's a really important insight. Now, in terms of new companies coming to the US to set up training, investing into the workforce, but what about the onboarding process? I think there's a lot of pitfalls here as well that employers can run into, and it's very important. And this is also sort of where we work together, right? Because we're involved oftentimes in counseling, whether that person is eligible, if they're bringing foreign nationals, they may have a core team that they want to bring over to launch operations. How do they do it? What can they do? Can they only staff their foreign nationals initially and transfer employees and not hire US workers? Those are the types of questions we're addressing on the immigration side. What are you addressing on the employment law side?
Mostly employment contracts. One of the things I've noticed, and again, this is just a general trend, it's not every employer that comes to the US for the first time, is the company will want to have contracts for everyone. So from the part-time receptionist, I actually did have a company that had an employment contract for a part-time receptionist, guaranteeing the receptionist all sorts of benefits and things that normally a part-time worker wouldn't necessarily have. Well, you can't take those things away after you've already given them to the employee without some consternation on the part of the employee. So being careful about who gets employment contracts. You definitely want your executives to have employment contracts so that you can put very specific termination reasons in there in case something unfortunately untoward happens. You want very specific bonus metrics. And if it's a commissioned person, you want very specific commission metrics in there as well. When they get paid, when they won't get paid, whether someone still has to be employed, whether the bonus is earned, like on what date the bonus is earned. This is where we pull in our tax and benefits attorneys as well, as our immigration attorneys. It's labor and employment, tax and benefits, and immigration all working together lots of times on these issues. If you do have executives that already have contracts with the company in their home country, and they're coming here in the US, and now their employment is being transferred from the home country to the US subsidiary. That's which we often actually advise. It's much easier in the US to have your employees be employees of the US subsidiary as opposed to the mother company in some other country. So we go through issues with that a lot, with explaining who should get a contract, who shouldn't. Definitely visas come up in that conversation. How long someone can stay, the type of visa to get. This is where we get our immigration employers involved for sure. And then also benefits. This happens so often where you'll want to give benefits, which is generous and lovely. You'll want to give these extensive benefits, for example, year-long paid maternity leaves. That's rather common in the EU. It's not common at all here. My first child, I got 8 weeks. I don't know about you, Kate. My second child, it was a little bit kinder. I got 4 months of paid leave. So it's not common at all to have paid maternity leave. It's not required, unfortunately, except for in certain states, and certainly not years of paid parental leave. So these are things that we counsel on. Look, if you're going to have your employees here in the U.S. for a certain period of time, there are benefits that we will need to discuss that they may get, they may not get, and the pros and cons of providing those benefits to their U.S.-based employees.
And sometimes I think what we see on the immigration side is you have the parent company sometimes transferring employees, giving certain types of benefits, putting people into certain jobs, even filing immigration applications from the home country. And then you have local HR who hasn't been informed of what they're doing. People are showing up, they don't have records, and they need them in case they're audited. And it may be different than what they're doing for the US based employees, even if it's a foreign national that they recruited here that they're sponsoring. And for our purposes, that can generate audits. It can generate site visits from the different government agencies involved, because when there are discrepancies, when people are working at the same job site and different entities are listed and different wage categories are used and the job descriptions don't match and these filings are going into the immigration agency, especially now with the use of AI, they are flagging this. They are looking for stuff like this. They are picking on it. And the worst thing, and one of the worst sort of faux pas that I see a lot of new companies make in the US is they allow the foreign nationals to go hire their own attorneys. So
dear heavens.
they're making, so you have a bunch of attorneys making representations on behalf of the company to a federal government agency. Job descriptions don't match, wage rates don't match, revenues don't match, investment information doesn't match. And that is all an audit trigger that can have serious repercussions for the company and even result in debarment from visa sponsorships in certain very egregious cases. So that is something to be very cautious of.
Not only an audit, but a lawsuit. I have had clients ask me, well, I just don't want to get involved in this H-1B stuff at all. I don't want any visas. So I'm deliberately not going to hire people that need sponsorship, or I'm going to make sure that I weed out the employees I have. And it's like, don't do that. Because that could be discrimination based on immigration status, which some states protect, and also discrimination based on national origin, which is a federal law. You make me feel better, Kate. I thought every now and then I have a difficult job, but yours sounds much more difficult with the movement of employees from overseas to the U.S. and then back again.
It's always a challenge, but it's a pleasant one. And I think, when we're working with employers that are receptive, even if, they've done things incorrectly to a certain point, but they're willing to take the steps to come into compliance, I think that's always a pleasure. And I will tell you that, I've been doing this for over 20 years, but there's nothing more exciting than helping a company launch operations in the US and seeing these foreign nationals that have dreamed of coming here and getting their visas, getting their statuses for them and their family members. I think that's what keeps immigration interesting. As they say in Hamilton, immigrants, we get the job done, right?
I agree. There's certainly been times where I've talked to clients and they're debating whether to come to the U.S. or to expand in the U.S. And I always say, oh, please, please, we would love your investment dollars. We would love for you to open up another location or, come here and give a boost to the American economy. We certainly, at least in my practice, and I'm sure in yours as well, we welcome those foreign employers.
Absolutely. And it's definitely, been an interesting year. There's been a lot of changes coming from the administration, but regardless, it's still a very important time. I think the, race for global talent is on, and the US is at the forefront of that.
Agree. Definitely agree.
Kelly, thank you so much for joining me today. It's always so interesting to talk to you, to hear about your practice, and I really appreciate your insights.
It is a pleasure to talk to you, Kate. So thank you again for having me.